Hello, everyone, and welcome to this weekly webinar produced by Business Performance USA. We love having you as our guests each week as we give these webinars on a variety of important business topics. I know you've come here to listen today about the basic truths of background screening. It's part 4 in a multi-part series, and this particular one is about evaluate your screening program for basic FRC compliance. So we're going to hear about how to evaluate your particular basic background screening program. Our presenter today is Nancy Lynn Roberts, and I am Cynthia Stewart. I'm managing partner for Evermore Services, and I'll be your host for this hour. And I want to make sure that this hour is well worth your time. So please ask questions using the chat feature or the question feature on the dashboard, and I'll be sure to let Nancy know. And if you have any specific questions about today's webinar or other issues in the workplace, go ahead and write this down. Cynthia at businessperformanceusa.org. And by the way, you can watch Nancy in the previous webinars on demand at your own time frame. Just sign in to businessperformanceusa.org and look for webinars, or you can check us out on YouTube. Now let's introduce Nancy. Nancy is quite accomplished when it comes to background screening, and we're so happy to have her here with us today again because people have really looked forward to her monthly webinars. She is the owner of Track One, a professional accredited background screening firm, and she's Chief Operations Officer as well. She wears many hats, in fact, and most notably, she's a compliance professional and risk manager. She's educated as a business attorney since '92 with specific and long-term industry experience in entrepreneurial endeavors such as Track One, in healthcare, large healthcare system, in nonprofit and for-profit, staffing, employment, background screening, and technology. So she brings a wealth of background and experience. And she's established a record of reducing or managing risk for both entrepreneurial and established companies. She's built from the ground up comprehensive compliance programs and processes for large, multi corporate systems and small businesses alike. Nancy is a passionate advocate for improved compliance, professional certification, and accreditation in the consumer reporting industry, and she's been an active leader of the National Association for Professional Background Screeners since 2006, currently serving as chair of the Background Screening Credentialing Council that oversees the National Accreditation Program for NAPBS. So, I am so happy to introduce you to Nancy Lynn Roberts, and let's let her get started with this information I know you all are looking forward to. So, Nancy, I'm going to change the presenter over to you and hand you the screen.
Great. Thank you, Cynthia. Let me get clicked in here and get everything set up. Are you able to see everything?
Yes, we're seeing it great.
Fantastic. Let me get set up in the full. All right. Well, thank you for joining us today. And as Cynthia indicated, we're working on a series that has walked our friends, colleagues, and clients through the basics of background screening. And we really started that series with some statistics on how background screening is being used today and moved into what a user of consumer reports really needs to know and consider, and even talked a little bit about designing a great program from the starting point of having the right mindset. And the next two sessions in the series really have a little bit more to do with what I would call an on-site evaluation tool. So you will, through part 4 and part 5 of this series, have a checklist of questions to ask yourself about your screening program and practices that will really help you evaluate the areas where you might be at risk and may need to dig deeper and look harder at what you're doing. So with that, I'd like to tell you that we will be providing you, as I said, an overview. We'll provide you a checklist that gives you an overview for your program. We'll talk about the FCRA myths and goals for your program, talk a little bit about disclosures and authorizations and what you need to make sure your form is or is not doing. We'll talk about policy, procedures, and practices. We'll talk about what can and cannot be asked of your applicants or your candidates. And finally, we'll talk about appropriate decision making and processes based on a true business mindset and business application for your background screening program. So the first part of an on-site evaluation of your screening program really needs to start with what we call the first item on your checklist, and that is to ask yourself whether your staff is familiar with the Fair Credit Reporting Act and whether they understand how it applies to your screening policy, program, and practices. So in order to analyze that, one of the first things that you're going to need to do is really kind of get rid of an old myth that exists about the Fair Credit Reporting Act. And that myth says that the Fair Credit Reporting Act only applies to certain people, certain things. And while it's true, it is limited, it is much broader than a lot of people once thought. So the Fair Credit Reporting Act really does apply to all aspects of a background screening program when that program is being provided or that background screening service is being delivered by a consumer reporting agency. Now, the FCRA does not just cover credit reports. It does not only cover criminal reports, and it does not only cover your employees. So what that means is that the Fair Credit Reporting Act also covers any information that a third-party company might provide to you about an individual consumer, where that information is going to play some part or some role in your decision about whether or not to employ that consumer, give them an opportunity to serve, give them a place to live, grant them a loan, or do any of a number of other things with that consumer. So it's not just about credit reports. The other thing that we're sharing is that it's not just about criminal records. And what that means is it also covers things like employment verifications, employment references, driving records, drug screening records, medical testing. So a variety of information sources about a consumer are covered, in fact, by the Fair Credit Reporting Act, although the origins of the act really were just about the credit reports. And finally, the FCRA clearly does not just apply to your employees. The FTC, Federal Trade Commission, it has historically been the enforcement agency for the Fair Credit Reporting Act, as well as the interpretation agency. And they have issued a number of opinion letters, and there's even case law that makes it clear that the FCRA does apply to independent contractors as well as employees. Volunteers would be another example of a type of person that the Fair Credit Reporting Act applies to. So any kind of screening that you're doing involving an individual consumer where you're getting information by a third party needs to be filtered through the Fair Credit Reporting Act. Now, I think the other element of that first checklist item is that you really want to make sure that everyone on your staff understands the goals behind the Fair Credit Reporting Act. And let me just add that even if the Fair Credit Reporting Act doesn't apply in your particular scenario, the goals of that act are the principles that you need to think about when you're making decisions about how to handle a situation involving a consumer where you're relying on information about them and making a decision. So the Fair Credit Reporting Act was really written with the mind's eye of protecting consumers and making sure that their information is not just maintained privately, but really, more importantly, that information is used appropriately. Second of all, the Fair Credit Reporting Act has as a goal that that you be able to guarantee that information supplied by a CRA is as accurate as possible. So the original authors of the act wanted to make sure that the information that was being reported about a consumer was information that would be as accurate as possible, and that the people who were reporting that information were held to a fairly high standard. And third of all, the FCRA has as a goal that inaccurate or incomplete consumer reports could cause applicants to be denied jobs, or employees to be unjustly denied promotions. So accuracy, completion, and fairness of information are all key components of the Fair Credit Reporting Act. I would like to also add to that act that list is just the process that you go through in making your decisions and using information. The Fair Credit Reporting Act definitely wants to make sure that that process is fair, that there's notice being given to a consumer about what information is being found, and an opportunity to contest or dispute that information or correct that information before an adverse decision is made about them. So moving on into your evaluation process of your screening program, checklist item number 2 would read something like this. We provide Fair Credit Reporting Act and state law compliant written disclosure to, and we get written authorization from, every individual consumer prior to ordering a background check about them from a CRA. So obviously this checklist item has to do with your obligation to provide proper written disclosure and to obtain proper written authorization from the consumer before you go out and order a background check on them. Now, there are a number of things that you need to know about that consumer notice requirement. In looking at a lot of authorization and disclosure forms that our clients over the years have provided to us, I think this checklist is a good basic checklist of things that you need to think about. Remember that what the FCRA requires is that you provide written notice to the consumer that a consumer report may be obtained on them. The types of reports that are going to be requested, as you'll find out in just a minute, is going to be an important component of that, as well as who you're going to order that report from is also an important component of that. Now, that notice has to be clear and conspicuous. That means it has to be on a document that is completely separate from your main application. Now, in the paper days of application processes, that was easy. You just had a separate piece of paper, and on that paper you provided the written notice, and they signed off on that paper and said, yes, you're authorized to conduct this background check. But what we've seen over the past few years, as people management platforms and volunteer management platforms have rapidly evolved, is that many of those platforms have wrongly been designed to incorporate that notice into the body of the main application. And we are aware of a number of situations where enforcement actions or even court cases have been won with large fines and penalties based on the fact that this notice separate document from the main application requirement is not being met. As I said a moment ago, it is also important to make sure that you're actually providing the notice before the background check is requested. Now, again, with all of the integrations we've seen happen in the applicant tracking systems and the people management platforms, one of the problems that we've seen with many of the platforms that have been provided is that as the applicant fills out their basic information and they click on submit, they will submit off that data before they've ever gone and completed their separate authorization form. So making sure that the integration is written properly to maintain compliance with this criteria is important. Additionally, you need to make sure that you specify the consumer rights under the FCRA. There are specific documents that have been written by our federal government that every user of Consumer Reports should be using, and those rights, those consumer rights, are easy to find in English and in Spanish online. So you want to make sure that you're providing that information to your candidates before you hire them. Now, I do think it's important to note that the timing of the notice is different in the employment context when you're hiring someone than it is when you are looking at bringing them on as a tenant in a property that you manage or a property that you own. So the timing of notice needs to be evaluated differently, but in both situations, notice is provided. In the employment scenario, you're going to provide notice, pre-decision notice, and post-decision notice. And in the tenant screening environment, you only provide post-decision notice. In the employment setting, you definitely want to evaluate pushing off the background check to the post-conditional offer phase. That is something that is kind of a new evolution in background screening. A lot of companies were running their background checks really fairly early on as a screen out mechanism, for lack of a better term. But more and more what we're discovering is that the EEOC and plaintiffs are taking a position that needs to be pushed back to the post-conditional offer phase, and then the background check would be run. So if you haven't evaluated that trend, that's a trend you really should look at, and look at some of the risks that are out there of not doing that. And then finally, with your notice, authorization and disclosure, you want to make sure that you're meeting all of the state law specific requirements. Minnesota, Oklahoma are examples of states that have some unique checkbox requirements. So your form, if you operate in multiple states, or even if you have candidates that could have moved from other places, such that you're obtaining information about them from other states, you'll want to make sure that your form is compliant in all 50 states. So some of the other components of the consumer authorization requirements are obviously provided here. You want to make sure that you get a written authorization from the consumer in addition to disclosing the fact that you're going to run a background check. And you want to do that, of course, prior to actually requesting the consumer report. And again, it needs to be on a form that's separate from the application. And the written authorization from the consumer can be on the same page or the same form as the disclosure or the notice of the fact that you're going to run a check. So those two, the disclosure and authorization, can all be on one document, one form, signed after or signed prior to requesting the information. Now, of course, you want to make sure that you don't incorporate any sort of a waiver or a disclaimer of a consumer's rights or obligations under the FCRA. You can't waive your own obligations, and you certainly can't ask a consumer to disclaim or waive their rights. So that's one mistake that we've seen a lot of companies attempt to make over the years. And then next of all, you want to make sure that that you show specifically the name, the address, and a toll-free number of the screening firm that you're going to be using to conduct your background checks. The toll-free number element is very important. It's actually mandated under the Fair Credit Reporting Act that consumer reporting agencies have a toll-free number so that consumers can call them using that number. So make sure that you are working with an organization with a toll-free number, and that you're publishing their toll-free number as a part of that authorization and disclosure form. Then you also want to make sure that you're specifying the scope of the screening that's authorized, the type, the purpose, what kind of things you're going to be asking for, what kind of information you're going to be looking at about them. And also the scope of the authorization as it relates to you, meaning I'm going to conduct this background check and I can use it throughout your employment over a certain specified period of time. All of the entities that we own and operate can use it and rely on it, etc. You're going to have to specify some of that. And then, of course, you want to look to any state law specific requirements that may be out there in your particular jurisdiction. So we're moving through our checklist, and we're on checklist item number 3. Our screening policy is properly tailored to specific positions, business units, screening types, and/or properties. Now, this checklist item has really, it's always been one of the checklist items, but it has really taken a turn in the past year or two, as we've learned a little bit more about what the EEOC and even HUD has in their thinking about discrimination and disparate impact. So a properly tailored program is going to really customize the screening packages to the particular position, as well as to the particular individual. So make sure you're working with a screening firm that's helping you tailor those packages. We've listed on here some of the things that you should be considering as you're customizing your screening packages. And even in your policies, you need to identify those custom screening packages, what kind of information you'll be evaluating. So everything from the location where they're going to be working should be considered, the type of work they're going to be doing, the department they'll be working for, what authority level they have, their relationship to the organization, and the risk requirements of the position or the organization. The same analysis would apply in the tenant screening context as well. Additional things to consider as you're evaluating whether or not you have a properly tailored screening program is that you want to make sure that you're using different types of screening products for their different intended purposes. We will do a future program that just talks about the products, the pluses and the minuses, what you can get and what can be challenging. But identity verification tools, multi-state or multi-jurisdictional criminal and civil databases, state criminal and civil record repositories, sex offender and other registries, county level searches, motor vehicle records, credit reports. You can see the list of products and background screening products that can be used in a properly tailored screening program. So really the secret sauce to quality hiring is how you take the information that's available to you and mix it up to create a great hiring and screening process. So the other aspect of your tailored screening program is making sure that your decision-making criteria is also tailored appropriately for each candidate that applies with you, each application, and for each position that's being filled, whether that's a tenant position, if you will, or an employment or a volunteer position. Historically, what's interesting about this area is that historically, the position was that we didn't want people to discriminate. And so the best way to avoid discrimination is to make sure that that we apply the same decision-making criteria to every person who walks in the door. So we spent a decade or more in the HR area, and really even in the selection area, making sure that we had objective standard criteria, that the same criteria were documented and applied to everyone regardless of where they came from, what their background was. So, for example, companies typically would write a policy that would say anyone having a record of a violent felony level offense is prohibited from working for our company. That would be a standard, what I'd call a rule out policy. Well, today we have evolved in our understanding, or at least in our the interpretation of this act and of the impact, the disparate impact of some of those very objective standard criteria. And today it's all about individualized assessment. And what that means is discretion is required and everyone is looked at on a case-by-case basis. So how we do that is that we analyze an example of a provision that might be in a policy today, using the individualized assessment model, is we analyze each felony record for each applicant for each position, meaning we are going to tailor our decision-making process to the particular scenario. Now, there is an FTC CFPB opinion, and actually there's guidance. It's called their criminal records guidance, where they talk pretty specifically about all of the factors that need to be considered in that decision-making criteria. And that is something that you would want to build into your screening policy and make sure that you've addressed those factors appropriately. So black and white criteria are absolutely barred and prohibited by the EEOC, and they certainly currently are discouraged by HUD. HUD is trying to turn that into a prohibition. That's been litigated. They almost went up to the Supreme Court. Think it'll probably go back up there soon, but that's not resolved quite clearly on the HUD side yet. Now, checklist item number 4 as you're evaluating your screening program. We know what we can and cannot ask of applicants on an application, during an interview, after making a conditional offer, and before making an adverse decision. So that would be the statement that you are able to say about your screening program if you have a quality screening program. And what this really goes to is we're going to start with what can and cannot be asked on an application. We've had a major movement in this country called Ban the Box. It's been a state law movement, actually, where a number of states have said, we won't allow you to put on an employment application any longer a little checkbox or a little box where you as the applicant have to say previous felony conviction. So the Ban the Box movement is that we should not be asking on an application whether or not you have a previous felony conviction. Now, historically, employers would have that box checked or have that box on the application, and if you did not check that box and they later ran a background check and discovered that you had committed a crime, then that was a basis for not hiring you, because that was viewed as a misrepresentation. So the movement away from the Ban the Box really eliminates that opportunity to evaluate the willingness of a candidate to come clean about their past on the front end of the application process. Now, obviously, this ties in with the 2012 EEOC guidance that says that employers cannot ask about convictions on applications. And that's a part of the federal movement to support the Ban the Box effort, which has been happening at the state law as well. Inquiries there, I should add that even since these materials were written, there are more states that have been added to the Ban the Box state law movement, and there are some that are considering it. So you definitely want to stay on top of whether your state has passed a Ban the Box state law. So when it comes to arrest records, use of arrest records is not job related and consistent with business necessity per the 2012 EEOC criminal guidance. What's important about that is a lot of companies have looked at arrests as an indicator of a future potential for a conviction or a crime, and they've used that to rule people out of their organization. But as a country that has decided that you're innocent until proven guilty, the EEOC took a strong stance in their EEOC guidance that they issued and said, no, using arrest records is not appropriate. But what they did also say is interesting, and that is that the employer may make a decision on the underlying conduct if the conduct makes the individual unfit for a position. So, for example, if I were arrested while driving under the influence at 2 o'clock in the afternoon, and there is a breathalyzer test as a part of that arrest record, then if the position that they are looking at being evaluated for is a driving position, you might be able to use that arrest record to rule out putting them behind a wheel. But again, I think this is a slippery slope where the EEOC guidance has sort of this broad sweeping statement of, well, okay, it's all right to use arrest records in these certain situations, but when to apply that situation and when not to apply it is not very clear. So you have to be very careful there. You should also note that the FCRA at the federal level does have some restrictions on the reporting of arrest records. So you want to make sure that your team is familiar with that as well. So our final item on our checklist for today, again, remembering this is the first 5 elements of that checklist, is that we understand our obligation to utilize and exercise appropriate decision-making criteria and processes based on the type of screening we are doing. So this goes back really to that EEOC enforcement guidance, which starts from a premise that using criminal records in employment decisions can have a disparate impact absent additional factors establishing no such impact. So instead of saying there's not a disparate impact unless you prove there is one, this is saying we're going to assume there might be a disparate impact unless you can show us that these factors don't exist. So the factors that the EEOC says seriously need to be considered are the nature and the gravity of the offense, the time that has passed since the conviction or the sentence, the nature of the position held or sought. Those are the original green factors, if you're familiar with that. But they added to it that you also have to do an individualized assessment of the facts or circumstances surrounding the offense or conduct, the number of offenses for which the individual was convicted, the older age at the time of the conviction or the release from prison, evidence that the individual performed the same type of work post-conviction with the same or a different employer with no known incidents of criminal conduct, the length and consistency of the employment history before and after the offense or conduct, and any rehabilitation efforts like education or training or certifications or proof establishing that they've come clean. So these elements are all a part of that individualized assessment. And the last 2 are you need to be considering employment or character references and any other information about fitness for the particular position. And you need to be considering whether the individual is bonded under a federal, state, or local bonding program. So the EEOC, in short, has added a number of individualized assessment elements that weren't previously a part of what we used to know in HR as the green factors. Now, remembering that all of that EEOC criminal guidance really speaks to organizations that are employing people or hiring volunteers or independent contractors and are using screening various criminal records as a part of their program. So what does that mean for tenant screeners? Let me tell you that I think that what that means is that the HUD and others would like to see tenant screening move in this same direction. They have not fully achieved getting there yet at this point in the regulations or in the cases that have interpreted those regulations. But what we're seeing is definitely a push to move in that direction. So I think it's advisable if you just want to look ahead into the future to look at this EEOC criminal guidance and understand the thinking that the EEOC has and think about how you might need to tweak your tenant screening practices to fit the model that's been laid out for us by the EEOC. So as a wrap up, we've given you the first 5 elements of a checklist that kind of serves as an audit tool, a starting point for an audit tool for your background screening program. And really a summation of what we've tried to teach you today or share with you are the following takeaway points. First of all, we'll talk about the employee screening best practices. You definitely want to review your compliance based on the EEOC enforcement guidance from 2012. We really want to recommend that you order HIT verifications up front to increase your accuracy and to expedite your hiring. What that talks about is that when you order database records, a lot of companies are not going back to the original source and verifying that the information is still accurate before they report it to you. And that lower accuracy rate, certainly it's, the information is made available in a split second to you. But without that additional update, you really are lacking in quality and accuracy. And that can create tremendous problems, negative problems for you as an organization with the people who are applying with your organization. So by using some sort of a verified result, then you are going to really dramatically reduce your erroneous reporting rates and really improve your relationships with your applicants and your candidates, which obviously sets a great branding for your organization. Next, in the employee screening best practices is that you want to make sure you've reviewed your pre and post adverse action process. And you definitely want to make sure you're going far beyond criminal records in your analysis, and that you're looking at the Fair Credit Reporting Act and the various state laws that apply. And then you also want to make sure that you are considering probationary period pending your screening. So if you're bringing somebody on board before you've completed your complete screen of them, that conditional offer is there, and that you are giving some period of time, whether it's 5 days, 10 days, or 15 days, to work through the background check before you give them full access or full authorization to your organization. So using some form of a probationary period or conditional offer is recommended. Now, for volunteer screening best practices, there's been a lot of change in the volunteer screening space. Definitely there used to be a mindset of let's do the minimum that we can do at the lowest cost possible. And that mindset has really transformed. And I think that volunteer and nonprofit organizations are recognizing that in order to protect their mission and their brand, they really, and their people associated with that mission and brand, that they really need to be much more aggressive and forward thinking in their screening programs. And so we're seeing a tremendous change in practice for organizations who are retaining or attracting screening volunteers. So the best practice takeaway points for volunteer screeners is you want to make sure that you understand the risk of defamation and privacy claims. So even though the person isn't going to have a lost wage claim if you do something to rule them out, there are other types of claims that can be asserted against you that can pose a high risk. And that obviously doesn't even relate to the claims for negligence in retaining a volunteer, which can arise in the event that some sort of an adverse action happens against a victim, or there's some sort of a victim scenario as a result of something that candidate that you brought on or that volunteer you brought on has done. So another volunteer screening best practice would be pre and post adverse action. You want to make sure that you're doing both the pre and the post, and you understand that it applies to your process and that you are applying it properly. Again, you want to make sure that you're using verified reports, verified results, so that you have great accuracy, and you'll really actually end up improving the overall onboarding process for your volunteers, and you'll have fewer individuals upset with you because of wrong information being reported about them. And then finally, I really want to encourage people who are working with volunteers and nonprofits to think in the way that you would think about screening an employee, and go beyond just the multi-jurisdiction database search and sex offender registries. That information is, while it's a good broad scope, there's a lot of holes in that information, and going deeper and getting more accurate information is just going to make you protect your people and your mission better. So with that, we've gone through the first 5 elements of the checklist for your audit tool, and I hope you found this helpful. as you sit down to evaluate your own background screening program and to identify the questions that will help you uncover what you need to do to improve that. And with that, Cynthia, I'll turn it over to you.
Well, Nancy, thank you so much for giving us all this information. We really appreciate your historical perspective on background screening and your understanding of where the laws have come to today. And we know that if people will take your guidance, that they can create and craft excellent background screening programs. And we appreciate your time that you give to these webinars. Folks, if you haven't seen Nancy's former webinars, they're very informative. All you need to do is go to businessperformanceusa.org and you can watch her webinar series, and you can watch the other webinar series that we've been producing here at Business Performance. If you want to contact Nancy, you can do that. So write this number down: 1-800-600 8999, 1-800-600-8999, or reach through to track1.com, their website, and you can find out more. She also has FCRA certified screening professionals that can help you as well. So we appreciate that. Come back and hear her again for more on evaluating your background screening program. And we thank you for your time and for your attention and for joining us week by week. We will be producing these webinars on a weekly basis, so there's lots more information coming. Don't miss the opportunity to become a member, Business Performance USA. There's no cost for you to be a member, and you receive the privilege of viewing our webinar recordings and downloading business posters and charts and white papers and all kinds of other documents to help you in your business. Thank you for your participation today, and we hope to see you back. Go out and make it a great day. Thanks, everyone.